Hello, everyone, and thanks for joining us. In our recent article, we discussed the applicability of the doctrine of legitimate expectation in tax disputes. The doctrine is a common law principle that posits that public authorities should abide by the representations and promises made by them to members of the public and rely on to their own detriment. Now, the doctrine generally operates to prevent public authorities from reneging from those representations or promises. Discussions around the doctrine has come to the fore again as a result of the decision of the Tax Appeal Tribunal in the case of FIRS versus New Cross Petroleum Limited. Some years ago, the Nigerian Investment Promotion Commission, the NIPC, issued Pioneer Status Incentive (PSI) to New Cross Petroleum Limited for 5 straight years, as against the initial period of 3 years allowed by the enabling law. Subsequently, the NIPC wrote to New Cross Petroleum Limited, informing New Cross that PSIs granted to them for 5 straight years have been reduced to 3 years. Now, based on that reduction, the FIRS assessed New Cross Petroleum Limited to tax in respect of the years for which the incentives were reduced, that is, the 2011 to 2012 years of assessment. Now, there was a back and forth between the FIRS and New Cross, which prompted the FIRS to lodge an appeal with the Tax Appeal Tribunal. At the tribunal, the FIRS argued that the enabling law on pioneer status incentive does not cover upstream oil and gas companies, and as such, the incentive granted to New Cross by the NIPC was invalid. The Tax Appeal Tribunal agreed with the FIRS and held that the enabling law does not cover upstream oil and gas companies. Now, this raises some questions about legitimate expectation of taxpayers in tax disputes. Having recognized the PSI granted to New Cross for the initial 3 years and did not contest it, should the FIRS be allowed to buy? Should it be a tenable argument that PSI is not applied to upstream oil and gas companies? Should the NIPC, which is empowered by the enabling law, be allowed to reduce PSIs granted to New Cross after New Cross had utilized those PSIs? In our opinion, it would cause untold hardship to taxpayers if they are made to disregard representations or promises made by them to public authorities. To what extent can taxpayers rely on the doctrine in tax disputes? Look at a few precedents in Nigeria. In the case of Saipem versus the FIRS, Saipem obtained an advanced tax ruling, an ATR, from the FIRS to the effect that the non-resident company with which it had a contract will not be taxable in Nigeria, provided that that company performs the contract outside Nigeria. Now, subsequently, the non-resident company was assessed with tax in Nigeria, and Saipem went on appeal. On appeal, although it was found that Saipem did not rely on the ATR, nevertheless, the court stated that an advanced tax ruling cannot override the clear mandatory provisions of the law. As such, the doctrine of legitimate expectation was not applied to protect Saipem in that case. Again, in the case of Kenya Airways versus the FIRS, Kenya Airways, the taxpayer company engaged in air transport in Nigeria, over the years has been subjected to tax based on 2% of its earnings and in accordance with Section 14 of the Companies Income Tax Act. Subsequently, the FIRS assessed Kenya Airways to tax based on 6% of its turnover. On appeal, the Tax Appeal Tribunal held that FIRS was bound by its consistent practice of assessing Kenya Airways to tax based on 2% of its earnings and in accordance with Section 14 of the Companies Income Tax Act. Based on a review of the judicial precedents available to us, and as we have discussed in our article, one can conclude that although the courts recognize the applicability of the doctrine in tax disputes, the courts will seldomly apply the doctrine successfully in situations where representations or promises made by the revenue authority or other public authorities are in direct contrast with the mandatory provisions of the law. So the big question is, would it not be unfair to allow the revenue authorities or other public authorities to renege on the assurances to taxpayers and to members of the public? The narrow application of the doctrine adopted by our courts would, in our opinion, weaken the trust that has been reposed in our public administration system and the tax administration system. We're advised to exercise caution in relying on promises or representations made by the revenue authorities or other public authorities to them. For more information on this article and to read about our other publications, please click on the subscribe button below. Thank you.